Hello, hope it works. Um, hello, my name is Eva Laskowska-Litak. I'm assistant professor at Jagiellonian University in Krakow, and I'm happy to be the part of Recognize project. And today I would like to share with you some thoughts about intellectual property law and cognitive sciences, since that's also a part of the Recognize project. But before we even start, a few words about me and why I'm going to tell you a few words about intellectual property law. Well, first of all, because I'm intellectual property lawyer, obviously, and that's most important argument for it. Nevertheless, I think that the intellectual property law that we are used to think about is not commonly what we think the intellectual property law is about. Now, cognitive sciences and generally neurosciences tend to operate with notions that are already incorporated within intellectual property law, particular copyright law. Therefore, it seems quite interesting, if not disturbing, to show you how the overlap between intellectual property law and cognitive sciences actually function nowadays, and what are the possible future destinations of this conflict that tends to happen between intellectual property law and cognitive sciences. Now, as mentioned, a few words about me. I work at the Jagiellonian University back here in Krakow, Poland, and I'm specialized in copyright law, meaning that I'm supposed to know what copyright law is about and how to resolve the dogmatics of intellectual property law, copyright law, what's supposed to be protected under copyright law and what's supposed to be not, at least in theory. I also or I'm specialized in digital technology, so how the copyright law, patent law, design rights, or design law in general tends to protect things or solutions that are developed under new technological revolution, meaning mostly, and that would be the first slide, artificial intelligence. That is mostly the field we used to talk about usually nowadays quite often, especially if we think about chat gpt and how the chat gpt and so all the artificial intelligence general solutions tends to incorporate even more and more space within our lives. And that's mostly what intellectual property lawyers tend to um, discuss about nowadays, how the artificial intelligence or artificial intelligence solutions, artificial intelligence AI-based programs, computer programs, how they are protected or shall be protected within copyright law or within generally intellectual property law. But that's not only what copyright law or intellectual property law in general is. It is what we also called everything, or what is called everything that is more or less focused on our industrial life or our economic life circle of a product. For example, if we think about a software and the company or entities that issue some kind of software, that's not only the question of copyright law or design rights, or how the project is actually evolving, whether it is utility or model, not whether user interface is somehow registered or protected, etc. It's not only that, but also the company's name or the databases or the users and the data that the users left over their platforms, internet platforms, etc., and so forth. So all the questions relating to how we behave or what are our most important activities over the internet, or what kind of a behavior of consumers and users are most valuable from the economic and not economic side, from the perspective of producers. That is what is mostly a focus of intellectual property law, actually nowadays. But whenever we think about the intellectual property law from the historical perspective, we may also see that we may also observe that the focus bit shifted from what was of a great economical value for the producers, the right holders, booksellers in the 18th and 19th century, towards what is mostly valuable from the economic perspective, uh, from the perspective from producers, database producers, or internet service platforms. So that is all. So that is everything that might be more or less associated with intellectual property law. As you can see, these are the authorial works, or whatever we question, whatever we produce and create over the internet, the logos, the company's name, personal images also, at least under some jurisdictions, they are also a part or considered to be a part of intellectual property law. The privacy of users, so the data law and the privacy law that mostly is associated within the intellectual property law, although it's not only a part, or it is difficult to say without any hesitation that is a part of intellectual property law, due to the fact that we do not create our privacy. It is something that's supposed to be ours from the start with, and no one's supposed to have monopoly over the privacy of ours. And also technical solutions, products design, know-how. So everything that we usually, mostly in general, associate with with technological development, and what kind of activities are we performing over the internet. That is the intellectual property law in general. But if we think about it from the perspective of a legal order, it is considered to be a right, an exclusive right. So a right that is effective against any other people, without hesitation or without any exceptions, etc., and so forth. That allows me, the owner, to use and dispose of things to the exclusion of other people. So, for example, exclusivity, and that's most important thing or description of intellectual property law. The exclusivity is the essential element, the key element to think about the intellectual property law as a legal order, so that we might be able to exclude other people from exploiting our works, or from exploiting our logo, our know-how, the company's name, etc., and so forth. The exclusiveness is a most important part and key element to understand why intellectual property law is currently not working, and why actually we need a legal order for the intellectual property to be effective. Whenever we think about property, so a thing, a corporeal thing like an phone or a book or something like that, we may be able to physically exclude other people from the possession over a thing. But with regards to intellectual property law, it is not possible, due to the fact it is of intangible nature. So that's an idea or a solution or a know-how, something that we associate with intellectual property law, like a software. It's not possible to physically exclude other people from using it without having a legal order. So that's the reason why, or the most important justification for the intellectual property law to exist, due to the fact without it, there is no physical possibility to exclude other people from possessing my ideas, my solutions, or my software, for example. So that's actually how the definition works, and obviously that the definitions or descriptions of any legal order are quite difficult to see how they work in practice. But what you may observe from this part of justification or definition, description of intellectual property law, is the fact that it relates the intellect, the spiritual, mental, or even the rational element that is intellectual, incorporeal. We can't touch it, but everyone knows what is it about. So in other terms, intellectual property law is considered to be a collective term for a group of rights that relate to intangible intellectual goods. And the question is, what is this kind of intellectual good? What is this intangible good? And we often use words like intangible, non-exclusive, or non-rival to describe what is intangible, what is the intellectual property, what is intangible good. And I will use as an example to illustrate it what is the subject matter of intellectual property law, the words of Thomas Jefferson that he wrote to his friend in 19th century. So he mentioned that if nature has made any one thing less accessible than all others of exclusive property, it is the action of the thinking power called an idea, which an individual may exclusively possess as long as he keeps it to himself. But the moment it is divulged, it forces itself into the possession of everyone, and he, receiver, cannot dispose himself of it. But most important thing from this quote is as follows. It's a peculiar character. He who receives an idea from me receives instruction himself without lessening mine, as he who lies his taper at mine receives. Sorry, I can't see it. Receives light without darkening mine. And that's most important element to describe what is intellectual property good. The subject matter of intellectual property law, the idea, the intellectual incorporeal matter that may or may not have some kind of economic power or some kind of valuable power that it is of some romantic or non-economic worth that requires and justifies the exclusive protection, so that the legal protection, so that we create legal order in order to also consequently create legal normative framework, excluding other people from exploiting ideas, solutions, computer programs, databases, patent solutions, etc., and so forth. The subject matter, however, remains still incorporeal, intellectual, so that any possession, intellectual possession of it, means that we cannot dispose or exclude other people from their minds, so that they forgot what they saw or that they forgot what they read. We only can, and that's how the effectiveness of legal order is limited. We may only be able to exclude other people from economic exploitation of our works, our solutions, or our model or our products, whatever part of intellectual property system we think about. And speaking of the devil, there are several parts of intellectual property law that might be more or less interesting. We tend to focus on copyright law. That's the part I'm specialized in. But there are also several interesting branches of intellectual property law that might be interesting for you as well, like the patent law or design rights, or how the product looks like, or database protection. So what is the database, and what kind of investment was made in order to create a database? Geographical indications. So for example, whenever the wine came from most dedicated and registered geographical region, etc., and so forth, or even practical solutions, like whether this part of, I don't know, technological product supposed to be connected with another one, and therefore the machinery works better. So that's all branches of intellectual property law. Our today's meeting will be mostly focused on copyright law, due to the fact that the copyright law is, at least from one perspective, the simplest one, but from the other perspective is also a part or branch of intellectual property law that tends to have many problems, and many of these problems are associated with cognitive sciences and how the cognitive sciences challenges the paradigms of copyright law. But one disclaimer has to be made: don't forget about other branches of intellectual property law, due to the fact that are also quite important and mostly also based on the same basic paradigms, being as such being and we'll talk about them in a few minutes. But also the question, and one of the arguments why we suppose, or why I suppose to talk about copyright law in particular, is because the copyright law, at least as such, was is governed by several international treaties due to the fact that the intangibility and transnationality of infringement um, um, implies that many countries suffer from the same diseases or the same dangers like internet piracy. Consider these as an example, and that's mostly forgotten whenever we speak about the copyright law, in the infringement, internet infringements, etc. Whenever you think about the piracy, so for example, copying from the internet or the plagiarism, etc., and so forth, and the plagiarized work is published online, it does not only happen within the territory of one country, it happens transnationally, so internationally, without any physical borders of a country. Therefore, the question of copyright law and the effectiveness of legal order is also the question of whether there are enough sufficient globalized unified rules that govern all the countries associated within one legal agreement, just like the TRIPS or the Berne Agreement, etc., and so forth. So the copyright law was the part of intellectual property law that was firstly and most sufficiently unified. Already in 19th century, and that was one of the first international agreements that came in force and still is in force. It was the Berne Convention from 19th century. So already 19th century, there was the first international agreement unifying parts of copyright law over the world. And nowadays, as far as I'm concerned, but I haven't checked before the lecture, or before our meeting. So more than 180 countries were associated within the Berne Convention. So the first international legal agreement associating all the countries with an attempt to fight the piracy, etc., and so forth. So there are several legal agreements that govern the copyright law, meaning also, and that's also a part of dark side of the copyright law, it is quite difficult to change it. Since if you imagine several acts associated with different countries and quite a lot of countries that were governed and came in force several years ago, and some of them centuries ago, that needs to be changed. It is quite a difficult task to perform. And also there needs to be a unified front so that all the international agreements and all the international provisions would be changed and amended so that it is up to date and fit to the digital environment, etc., and so forth. Quite difficult, isn't it? So that's also the dark side of the copyright law. It is governed by several international treaties. These are like the TRIPS agreement or WCT. It is World WIPO Copyright Treaty, so the World Intellectual Property Organization that's supposed to govern some of the treaties, or WIPO Performance and Performance Treaty, so all the questions relating to neighboring rights also associated within the copyright law, but we will not focus on them right now, although they are quite important as well. So they are governed within international treaties at the international intergovernmental level. But nevertheless, most of them are based on quite basic paradigms that haven't changed since 19th century, meaning that they all tend to protect a result of intellectual effort. It obviously means something different respectively of jurisdiction. For example, within the continental Europe, we tend to protect within copyright law author's own intellectual creation, meaning creative choices of mind that were manifested to other people, perceptible to other people. But several years ago, within the jurisdiction of United States and the Commonwealth, there was a legal interpretation that we suppose the authorial work supposed to protect the sweet of brow. So what not maybe the question of the originality or creativity of my choices, but the question of whether my choices were difficult to make, or whether I took an investment, intellectual or temporal investments, in order to create a product and distribute it over the market. So as you can see, there are some differences in justification how we interpret alone the question or the notion of a work, the copyright subject matter. Nevertheless, irrespective of jurisdiction, we tend to focus on the result. So there is artifactual or artifact that's supposed to be protected, and not a performance or a process of created effort, etc., and so forth. Although there were some attempts in the past. In some jurisdictions and in some branches of intellectual property law, there are also the possibility to protect the result of intellectual and financial effort, like, for example, the database. So whenever the producer of a database takes a financial effort in order to create a database, there is a possibility to grant him or them or her exclusive rights over it. It's not quite copyright law, it is sui generis right, but it is somehow more or less related to copyright law. Nevertheless, we will not focus on that. However, I would like you to remember that it's not only the result of intellectual effort. There are some attempts and there are some branches and legal orders, frameworks, where we may be able to protect also the financial effort. Now, irrespectively of whether it is intellectual or financial effort that is protected under copyright law, or any kind of industrial property law, intellectual property law in general, it is still based on a paradigm to protect intellectual intangible subject matter. For example, within the patent law, there is a solution, an idea protected. So we describe the idea within our registration form. It is protected how it is described and how it's supposed to work, what kind of effect it's supposed to perform, etc., and so forth. So it is an idea that is registered within the patent that might be protected. And within the copyright law, we protect the manifestation of our original thoughts. So how we created it and how it was manifested through our creative choices. Usually, it is also based on an assumption that the manifestation, so the effort, the artifact that's supposed to be protected, supposed to be perceptible by mind. So we do not tend to, in general, intellectual property law, copyright law in general does not protect how we taste, or does not protect smell or taste, like taste of a cheese, because it is not actually, and we will challenge this paradigm later, it is not actually perceptible by mind, it is perceptible by our senses. It might be the question of how it was described. Nevertheless, in the second part of our today's meeting, I will show you how this paradigm is challenged by the cognitive sciences. The basic assumption is, however, it's supposed to be intellectually engaging, so that we perceive it by our mind, by our intellect, at least by the senses of sight or senses of hearing. But you will see in the next part how we may challenge this assumption. Now, the last and not least, intellectual property law is based on a paradigm to grant monopoly rights, and that's the consequence of what I told you earlier, so that it is not possible to effectively protect our result from other people, from exploitation from other people, if not the legal author creates legal barriers, normative limitation from um, granting a right holder possibility to exclude other people from economic exploitation of our work. That's how we call the monopoly. And obviously, each monopoly is not an absolute right. There are some exceptions. Like, for example, whenever we use something, there are some exceptions that we use to call a fair use within the Commonwealth and the US systems, and you probably have heard about it. That's how users usually explain why the use works, or the citation, the quotation, exceptions, etc., and so forth. So there are some exceptions in order to restore the balance, because no absolute power is something that we need to have within the legal order. What I would like you to remember, however, is the exclusiveness, that it is our rule, the legal rule, within the intellectual property law, that is granted to one person or people who created together a work or a subject matter of intellectual property law. And because it is a rule, the exception is supposed to be radically interpreted, so that we have no doubts. The doubts should be interpreted favorable to the right owner. Now, before we start the next slide, I will take a moment of breath and a moment of pause, and we'll start the second part when I show you how the cognitive sciences and neuroaesthetics, neurosciences challenge these basic paradigms of intellectual property law, based or illustrated on the example of copyright law. So stay tuned. Thank you very much.